What happened this time, Mr. Montana?
Sorry, Chair. Chair, I was feeling a bit cold.
Oh.
And thought I would go and get a vest. And by the time
Yes.
I realized that it was still late, I just abandoned and came back quickly to be on time. Sorry, Chair.
Okay, no, that's fine. Okay, Mr. Soni.
As you please, Chair. Chairperson, you will recall that when Ms. Ngoyi gave her evidence, she dealt with the allegations that had been made in the Siyangena matter in the High Court. Since then, the High Court has pronounced judgment in the Siyangena matter. So rather than put those allegations to Mr. Montana, I would like to put on record what the court's findings were in regard to those allegations that Ms. Ngoyi testified to. So what I will do is what we did on the previous...
I assume that this means we have moved away from the Swifambo matter?
Yes.
Yeah,
yes.
Okay, all
right. Chairperson, the approach I intend adopting is just to refer to particular paragraphs in which significant findings were made.
Okay, all right. If you could start by giving the names of the parties and the case number.
Yes, as
and
you
the high and which high court and so on.
Yes. Chairperson, this is the judgment in the matter of PRASA against Siyangena Technologies and retired Justice Goldstein and retired Justice Joffe and intervening parties being Unite Behind. Intervening applicant being Unite Behind. It is a judgment of the full court, Chairperson. May I, just so that we have the full facts.
Do you want to read the case number?
Oh, sorry, as you please, Chairperson. It's, the case number is 2018-14332 and 2018-11314.
And the judgment seems to have been handed down on the 8th of October,
on the 8th of October 2020 by the full bench. Chairperson. I just need to point out that there had been a previous application.
I'm sorry, and it's the Gauteng division of the High Court.
It's the Gauteng division, as you please, Chairperson, in Pretoria. What had happened, Chairperson, and this is a matter that Mr. Montana, I think, has referred to previously, that certain persons applied to be admitted or to be able to file affidavits. And a full bench of the High Court prior to this judgment had allowed them to file affidavits. This court, however, looking at the law in relation to what evidence may be taken into account, decided that on the basis of the Masetla judgment and a judgment of the Constitutional Court, that only the relevant parties, namely PRASA and Siyangena, the affidavits presented by them could be taken into account. So I just present that because it addresses an issue that had been raised by Mr. Montana, and you'll recall, Chairperson, that he also raised that in the Swifambo matter. So this judgment doesn't deal with the allegations or the answers that he gave in his affidavit in this matter.
Can I say something quickly?
But very quickly, please, Mr. Montana.
Thank you, Chair. No, Chair, it is a fundamental matter. Chair, I just want to put on record, Mr. Soni is partly right. We didn't apply. PRASA went to court. I think it has lost a couple of times in these matters. I think on four times. Now, their last review application that they made, there was a full bench of 3 judges, which then ruled that it is not in the interest of justice for allegations to be made against officials and they are not given an opportunity. So it didn't apply. We invited by the court. Chair, I filed a detailed affidavit with a lot of evidence. 2 weeks before that matter, the whole bench was changed. A new bench came in. And our own affidavit that we were asked by the court to put together, we're told that that evidence is no longer admissible. So our affidavit that we were asked by the court, so we're not taken in the thing. But when you read the judgment, you can hear, Chair, that in fact it was. But I won't argue that. I accept what Mr. Soni is saying for the sake of progress, but I think we should record it properly, Chair.
Yes.
In that regard. Thank you.
Okay, no, that's fine. But for what it's worth, it would be good, maybe that will be in your, maybe that is in your affidavit. It would be good to get that factual background that you just outlined later on.
Chair, it is the detail. Okay. The matter is dealt with in detail in my affidavit.
All right. Thank you. Mr. Soni. Yes,
as you please. Chairperson, Mr. Montana is right. A full bench, and that's why there are 2 case numbers here. A full bench had granted them, the persons who asked to submit affidavits. But this court looked at that, and based on the principle that they didn't have a direct and substantial interest in the proceedings that were before them, decided that they would not take the vermins in those affidavits in account.
No, check. Can I again? I don't want to disturb Mr. Soni. It must be put on. We're putting on record that we never applied.
Yeah.
The court did. That's the first thing. But the second thing, Chair, I just want to say, Mr. Soni, I don't want to debate it, but we cannot say the court decided to take because these guys don't have substantial interest. If you say in your affidavit that Siangena was awarded the contract in a corrupt way, and you mention people's names, and then you ask them to come in, and then you say, then surely, Chair, there's a big problem. I just want to say that, but I deal with it in my affidavit.
Yeah.
So I just want to emphasize, we didn't apply.
Yeah.
The court emphasized, Chair.
Yeah.
I prepared an affidavit and I said, I want to assist both parties, both Siangena and PRASA, because they seem to be getting their facts wrong. I provided those and said they can be used.
Yeah.
But the court ruled not from any application to say it is not in the interest of justice. And I think that that judgment by the three judges was for me it was a right decision because it dealt with the issue of the interest of justice. And I think in this particular case, of course, I don't have an interest in the matter. But if I'm referred to, I don't have an interest in the matter. Surely, Chair, that the interest of justice is being undermined. But I think let's proceed. I just wanted to record those facts, Chair.
Yeah, Mr. Soni.
Chairperson, can I just to finish this part? It's addressed at paragraphs 34, 35, and 39 of the judgment.
Yes.
On this very issue.
Yes.
Mr. Montana, I just want to read to you relevant parts of the judgment, and at the end you can comment on it. At paragraph 43, the court says, the background facts are detailed because they provide insight into how the relationship was formed, and it's talking about the relationship between Siangena persons and PRASA officials. The details of the pattern of conduct show how increasingly the participants came to ignore the procurement requirements, the need to continuously act in good faith, seeking the best technical outcome to meet the requirements and at the most economic price. Then at paragraph 44 it goes on, The background concerns two preliminary phases, the pilot project and an extension of the pilot project. Those phases preceded the phases presently in issue. The phases in issue are phase 1, the phase 1 extension, and phase 2. And in paragraph 45, the background reveals that initially a sparing and economic approach to the installation of the equipment in issue was adopted. The installations were intended to be effective and efficient and focused on the needs of PRASA. The initial approach, however, was abandoned on or shortly after the introduction of the respondent, that's Siangena. The scope, extent, and cost of the work increased dramatically, and the work was precipitously proceeded with in the absence of a budget or any planning and in utter disregard of the procurement process, while the functionality of the system decreased. Then can I refer you, Chairperson, to paragraph 53, sorry. Despite the absence of a budget to pay for the work, concerns about the cost and suitability of the access gates, the intention to install local gates, and without a procurement process and any prior assessment of recommendations, Mr. Montana, acting on behalf of the applicant, directed Mr. Gansho to contract the respondent. At paragraph 54, the court says, the contents of internal documents were manipulated in an attempt to justify the directive, conceal the prior commitment to the respondent, and used as a basis to expand on the scope of work. In paragraph 55, the court says, in the final quote, meaning quotation, the respondent expanded on the scope of work, reduced the functionality of the existing work, and increased the price of its proposal. And at paragraph 55.4, the court says, Mr. Ferreira and Mr. Montana met on the same day as the final quotation, namely the 17th of March 2010. There is no record of this meeting. Mr. Ferreira required a formal acceptance of the proposal, which exceeded 225 million rand, by no later than the 19th of March 2010. The respondent does not disclose the response from Mr. Montana. In paragraph 57, the court says, Mr. Montana, according to Mr. Gansho, approved the appointment of the respondent and instructed the implementation of the decision. And at paragraph 59, the court says, the conduct that resulted in the awarding of work to the respondent became a blueprint for the award of work in excess of 6 billion rand to the respondent. Then, dealing with phase 1, starting at paragraph 60, the court says, the expansion of the ISA-MS system, that's Integrated Security Access Management System, beyond the World Cup 2010 was not planned by the applicant. There was no approval from the executive, and the work was not budgeted for in the allocation of funds. Paragraph 64, a perception that there was no need to comply with the procurement policy in regard to the extension of the work and the appointment of the respondent was established. The perception resulted in a failure to implement the procurement policy and manage the procurement process. Mr. Gansho instead managed the procurement process. Paragraph 67, the court says, the documents provided to potential bidders selectively included and manipulated the contents of the broader, more general SARCC specification to the exclusive benefit of the respondent. The documents did not comply with the procurement policy. In paragraph 69, in the first sentence, the court says, the bids were not checked for compliance. And then in the last sentence of that paragraph, the court continues, the BEC recommended that the bid by the respondent, BEC recommended the bid by the respondent, despite the bid being approximately 60% more than the competing bid and the excessive rates charged by the respondent. Paragraph 70 says, the flaws in the procurement process were concealed. The minutes of the meeting of the BEC were manipulated to remove irregularities and bolster the recommendation of the respondent, and the employees who were interviewed attempted to conceal the absence of an RFP. Paragraph 71, the recommendation of the BEC was rejected by the group CEO and, more importantly, by the CTPC. Chairperson, I understand that to be Corporate Tender Procurement Committee. There's some acronym that is also for what, cross-section or something?
Cross-function.
Cross-function. This is not the one?
No.
Oh, okay.
The one...
CTPC.
CTPC is the adjudication committee.
Okay.
Of Mr. Tiro Holele and Martha Ngoy.
Okay, all right.
Well, that's of course in the Swifambo matter.
No, Chair, even on this one, I'll come back.
Yes, okay. Continue.
Paragraph 72, in the aftermath of the CTPC decision, there was a concerted effort to manipulate or create documents in an attempt to conceal the decision of the CTPC and the irregularities in the procurement process. And then at paragraph 73, the CTPC was simply bypassed and the tender placed before the FCIP, and that acronym, Chairperson, as I understand it, is the Finance Capital Investment Procurement Committee, and that contained inaccurate, incomplete, and misleading information. At paragraph 74, the court says the tender proceeded to the Board of Control. However, there is no indication that the board made a decision to contract with the respondent. Paragraph 75, in order to conclude a contract, prior approval had to be obtained from the Minister of Transport, and approval of the contract had to be obtained from the board, none of which occurred. And then at paragraph 75.4, it says Mr. Montana nevertheless signed a JPCC contract. And then at paragraph 76, the judgment says the flawed process was concealed, and it sets out the basis on which that is made. And then at paragraph 77, the court says, as regards phase 1, the process that resulted in the awarding of work to the respondent in phase 1 failed to comply with the constitutional, legislative, and regulatory framework stipulated for a valid procurement process and contravened the applicant's own procurement policy. And at paragraph 80, as regards phase 2, the court says the extension of phase 1 and phase 2 suffers from the same flaws as those found in phase 1. Paragraph 81, the method used to secure the appointment of the respondent was the same as the extension of the pilot project and phase 1. An unsolicited bid from the respondent, a requirement for the respondent's specific brands, the restriction of the procurement process, deviation from the required process, ignoring of adverse decisions, misrepresentations, misinformation, and concealment of the material facts. Says this, paragraph 83, despite the absence of any planning, an unsolicited offer from the respondent was entertained and acted upon. And paragraph 84, the court says the procurement process favored the respondent and sets out how that was achieved. Paragraph 84.7, it says the group CEO is required to consider a recommendation by the CTPC. The CTPC did not make a recommendation. The group CEO nevertheless made a recommendation to the FCIP. The board was required to approve the appointment of the respondent, terms of the contract, and any subsequent variation. The board did not do so. Mr. Montana did so without authority. Paragraph 87, in the course of phase 2, extension to phase 1, documents were created that contained misrepresentations, misinformation, and concealed material facts. And paragraph 89, in the course of phase 2 procurement processes, documents were created that contained misrepresentation, misinformation, and concealed material facts. Paragraph 92, the court says there was an additional allowance of 905 million rand, mainly for maintenance and a warranty that was already included in the notice of appointment for phase 2, where it was accepted by the respondent, but not included in the JBCC agreement. That, Chairperson, as I understand it, is Joint Building Construction Contract, JBCC. And then at paragraph 92.2, the unsolicited offer was irregularly entertained by Mr. Montana and Mr. Pungula. 92.3, the respondent provided a bid, and 92.4, Mr. Montana signed the addendum agreement. 93, there was no procurement process. Paragraph 94, the contract and its implementation resulted in works which were not fit for purpose. At paragraph 96, the court says the applicant, meaning PROSA, discovered that persons and entities connected to the respondent and persons within the applicant, Mr. Montana and Mr. Gansho, were involved in various property transactions. In the face of it, the participants must explain these transactions. There are serious concerns that there was wrongdoing which needs to be investigated. The property transactions, at the very least, contravene the professional and ethical standards required to be maintained in public administrations, and those obligations with which all officials and other role players in the procurement system, including the respondent, must comply in order to promote mutual trust and respect and an environment where business can be conducted with integrity. Paragraph 98, persons who are complicit in maladministration, impropriety, or corruption should not be permitted to profit from an unlawful tender. They should be forced to make full restitution, even if this results in financial loss to them. The existence of corruption is to be inferred from the fact that a multitude of irregularities exist, that there is an absence of a candid explanation from the tenderer. In paragraph 99, the fiscus is poorer as it did not receive fair value for what it had paid. And then at paragraph 103, the court says Mr. Montana was involved with property dealings which had unusual features. An amount of 2 million rand was paid by a company for no apparent purpose in one of the transactions. Mr. Montana did not have sufficient funds to purchase the Hurlingham property which he negotiated to buy. It is apparent that the funds for the property were not to be sourced in the hands of Montana. This being so, where were they sourced? The inference is irresistible the funds are being provided by a third party for an unknown reason. Individuals do not normally provide funding in the millions for no apparent reason. This being so, the evidence is irresistible that the respondent was providing the backing. And at page 104, in the middle, in the third sentence, the judgment says, Mr. Montana was involved in numerous property dealings. These activities are not consonant with this activity as a senior employee of the applicant. In the ordinary course, the funding available should not readily have been available. And then at paragraph 131, the court says, the discovery of corruption was also impeded by the tyrannical manner in which the applicant was controlled by the erstwhile group CEO, Mr. Montana, and at paragraph 137 says, we are of the considered view that although the delay period of 10 months may render the application to have been inordinately delayed, the circumstances under which the delay occurred, as explained by the applicant, persuade this court to grant condonation. And then the order, Chairperson, is set out at paragraph 170, and the effect of the order, Chairperson, if one looks at 171A, the signing of the JBCC contract dated 31st March 2001 is declared to be unauthorized, and C, the signing of the addendum agreement dated 19th September 2014 is declared to be unauthorized. And at paragraph 170.3, the JBCC agreement dated the 31st of March 2011 is set aside. That's A. And B is the JBCC agreement dated the 1st of July is set aside. And C, the addendum agreement dated the 19th of September 2014 is set aside. Chairperson, just for completeness' sake, I should just point out that at paragraph 170.5, in terms of what was the just and equitable order, the court said work had been done and an independent engineer should be appointed to determine what the amount is that Siangena should be allowed to retain from the monies paid to it. That, Chairperson, is the judgment, and it is the judgment of Mr. Justice Lamont, concurred in by Justice Ralunga and Justice Hughes.
Yeah, those were the parts that you
Yes.
considered important to read into the record. Yeah, okay. I think you had said that Mr. Montana could then comment if you wish to comment.
Yes, yes, Chairperson.
Mr. Montana, do you want to say? I know you have already commented, so I'm obviously not inviting you to say the same thing, but if you wish to say anything.
No, no, Chair, I'm just going to ask you to give me time to reply to this.
Yes.
When Mr. Soni was reading this judgment, part of me was seething with anger. And at some stage, I was also laughing. How can the judges do this, Chair, to this country? one of the most scandalous judgments, suspicion of wrongdoing, inference, and all of those things. Then just 2 weeks before we go to court, the judges find reason, the judges are changed, chair. New judges are brought in, and then our affidavits that provides the facts on this table, on this matter, cannot be considered. And a judgment so similar, Chair, to the Sufambo judgment. You remember I spoke about the SCA judgment? So the SCA judges and the judges in Pretoria think the same. They think that this thing was under control of this, what is it, tyrannical Montana. The SCA judges say the same thing. Chair, let me address this thing. I want to address the facts, and Mr. Soni has read the judgment. I'm not party to this matter, so I can't take it on appeal. And I can't call the judges here to come and cross-examine me. I wish if I had the privilege.
Yes, just 1 second before we do that. You have said that you had, at the invitation of the court, submitted a detailed affidavit. Is that correct?
Chair, that's correct. Not Montana alone.
Yes.
All the people who participated in that process.
Yes.
I never participated. I was a CEO.
Yes.
So I think there were 8 people who were mentioned
Yeah.
by Mr. Ms. Ngoye in the affidavit, Chair.
Yes.
Now, this affidavit, I think if there's who's happy with this kind of judgment? Surely, Chair, that Versmans, Ms. Ngoye, Mr. Molefe will be celebrating, because they were able to get judgments almost similar at the High Court, Gauteng High Court, South Division, as well as in the North. Chair, the changes of judges, and I don't know what the judge president considered, one of the most scandalous things, and I want to go into detail, Chair, if you could allow me, because I think
the reason why I was referring to you having filed an affidavit was that I was wondering whether it might not be convenient to hear what you have to say after looking at such an affidavit or not. But I assume that those affidavits, Mr. Soni, even though the ultimate court that gave this judgment excluded them, they are available somewhere. At least his.
Yes. Chairperson, let me, are you looking at the affidavit?
Particularly his affidavit that he was not included.
Yes.
Part of what's in my mind is this, that he was no longer at PRASA when the litigation was launched. Is that right?
Yes.
He was no longer at PRASA. And yet he was a significant player in the transaction, isn't it? And affidavits were placed before the court by PRASA and I guess Yangena. But somebody who may have known quite a lot about the transaction, his affidavit was not there. I'm not saying that it was a wrong decision or right decision to include or not to include his affidavit. I'm just thinking that, a court is able to, or not that it is able, this is what courts do. They decide disputes between parties. They are able to say, well, both parties put your facts before the court and the court decides. But an inquiry such as this one might go broader.
Yes.
In terms of facts, because it's not deciding, it's not litigation. So I'm just wondering, I was just wondering whether it might not have been convenient to listen to him knowing what the affidavit says, but maybe if that's something to think about, and I should just give him a chance to comment.
Listen, let me suggest a way forward. We were obviously bound by the court judgment as the evidence leaders. Now, Mr. Montana says that what he said in his affidavit, which was presented to court but not considered by the court, may throw a different light on some of the issues. Now, without interfering with the court judgment, of course, you as chairperson would be able to take that into account. In your report, you would say there was this judgment, but my scope is broad. But one is looking at a legal process, and I want to take the process forward to give you the maximum scope that you should exercise. To be fair to Mr. Montana, but also not to cast aspersions on the judicial system. Is the process...
But Chair, can I object to
No,
that?
can I please finish?
Let him finish, and then I'll give you a chance. Let him finish first.
Not on the substance of the matter, Chair. Because I think we've discussed previously. And I think we need to take a decision. Earlier on, Chair, I was dealing with the ANC issues. It's time for me to respond to the judgment, to what the judges have said. It's for the second time, Mr. Soni spoke about the fact that we don't need to cast aspersions.
Or you want to emphasize that you...
No, Chair, but all of us, the only thing that is above all of us is the Constitution of this country. If I need to take on the judges, as long as I don't cast on a factual basis, I address them.
Yes.
I can't have this thing put before me to say, don't cast aspersion and everything.
No. I'll let you say what you want to say. Let him finish first.
Chairperson, I understand Mr. Montana's desire to put his version in regards to the Siangena matter, because we've now had a judgment that seems to reflect badly on him. What we need to do, though, Chairperson, is to consider whether the best and efficient or the most efficient use of the Commission's time should not be along the following lines. We received Mr. Montana's affidavit, the one he gave to
the court,
to the courts, which was not taken into account. We know what that affidavit will say. You look at the affidavit in your capacity as chairperson. We as the legal team look at it. And then if you decide that there should be input, oral input on that, we set a time for that. It will obviously have to be limited. But that would give Mr. Montana every opportunity to clear his name if that's what he wants to do. What, though, we need to be concerned about, Chairperson, is the limited time we have available. We spend now on this, Mr. Montana's response, without anybody knowing what the response is. It's going to take the rest of the day.
Oh, okay. I take what you are saying to be to say, is it not better that Mr. Montana gets an opportunity to say what he wishes to say when we have the affidavit, and therefore know in advance what he's going to say. That's what you are saying. That's, I think, consistent with what I was thinking. But so I must just say that, you see, as we look at these issues where a court has made certain findings and has given judgment, one needs to, on the one hand, bear that in mind. But on the other hand, bear in mind that because of the different functions between the court and the commission, and as well as issues which might, for the court, they might be narrower, for the commission, much wider. There may be circumstances where the commission might need to hear more than the court had before it. I think of an example that will resonate with you, I think. You will remember during the 80s when labor law was in its infancy in this country, that when there had been a judgment by the then Supreme Court on a matter affecting a dismissal, when the employee or a trade union went to the industrial court to challenge the fairness of the dismissal, usually you'd find lawyers for the company, for the employer, saying, no, but the court has decided. But what the court would have decided is whether the dismissal was lawful or whatever. And the industrial court would look at the question of whether the dismissal was fair. So the industrial court could still look into the matter. So that's what crosses my mind as I think about the fact that there may be situations where there is a judgment, but because it's two different forums with a different scope of inquiry, it may be that there may be circumstances where the commission has to hear something that the court did not hear, but one has got to bear in mind obviously various things, the time constraints, but also the issue of fairness to somebody affected, such as Mr. Montana, especially where he did not get a chance to, his side, his facts, as he knows them, were excluded. So it's something that one may need to tread carefully on, but it's something that one might need to look at with a view to making sure that, one, there is fairness, but there is proper consideration for the time constraints that one is working under, and then take it from there. That's what's crossing my mind. Does what I thought would resonate with you resonate with you?
I accept that,
Yeah.
fully, but it's not a question of commission not really looking at it, as would have been under different jurisdictions of legality and unfairness.
Yeah.
The only point I want to make, Chairperson, is we are going to base it on an affidavit that is not before us. And it would be in the public interest to know what was before that court that it did not take into account. deliberately for good or bad reason.
Yeah.
But he did not take into account.
Yeah.
And what Mr. Montana is maybe saying to me, I'm not saying is, may be different from that. And so we need to be careful that when we are determining whether what Mr. Montana would have said in that court might have produced a different outcome, one has the necessary facts. And we don't have that in the absence of Mr. Montana's affidavit.
Mr. Montana, before we move further, let me ask the question. In your affidavit, do you deal with, or no, probably you don't deal with this judgment, or do you?
No, Chair, in the latest that I've provided, I've added a paragraph to the affidavit that I've submitted.
Yes.
And for Mr. Soni's information, one of my annexures is my affidavit that I tabled there, Chair.
One of your annexures?
To my affidavit is my affidavit that I placed in the High Court.
That is, you have given that to the legal team, or not yet?
Well, Chair, it is previously. We've discussed it previously, but we said we are allocating tomorrow, Chair.
Okay.
So I'm hoping that we'll deal with the issue, Chair.
Okay. Well, I'll tell you what I'm inclined to do. I'm inclined to first see what you have to say, and maybe it's that affidavit and whatever, before I let you then deal with it. Is that fine with you?
Chair, can I suggest a different approach? The judgment has been read.
Yeah.
And you see, the issue has nothing to do with me, Mr. Soni. Well, I'm not dealing, my entry into this issue has got nothing to do with me. There's nothing in this judgment.
Yeah.
It talks about participants. It doesn't say Mr. Montana did that. It infers, we believe, we think wrongdoing may have been done by someone and then mention property. Chair, I'm not here to defend.
Yeah. Yeah.
There's nothing to defend. I didn't come to the commission, Chair. I came to assist the commission.
Yeah.
To put facts on the table. The facts mentioned in this judgment are false, firstly.
Yes. Yeah.
Secondly, it is not only like Montana's affidavit. All the people that were invited by the courts to file affidavits, because the court said it's not in the interest of justice. Okay, Chair? To file, not to be given the opportunity to respond. And of course, I welcome that opportunity. I say, here's a court. We've been criticizing the courts. Here's a court. The judges say, no, but you can't be making these statements. Let the people, and I responded not in each and every detail, Chair, but I filed a very detailed affidavit with annexures to prove that the allegations that were made were false. There were 7 other people who were asked by the court to say file affidavits. They did the same, Chair. They were admitted. And I want to say it boldly here, Chair. If my affidavit and the affidavits of the 7 others were admitted, they were admitted because the court has asked for it. And then just before the hearing starts, in that court, Werksmans come and say, there's no way they can be admitted. Say, no. When the court took that decision, the two parties, the two main parties, which is Siangena and Pras, were to be, they should have agreed to that issue. Now, it's a court matter. It's the rules of the court that I do not know. I'm not challenging that. But the court has invited us. And then the court, and the court then says, comes to a determination that the judges who were there before, who said it's in the interest of justice for these people to come, they come back and the new judges say, no, we shouldn't. Chair, I want to say that there's no way the court would have arrived at this judgment, append this judgment, if they agreed to accept
those affidavits.
Those affidavits that the court had asked us to do. But Chair, I think the fair, in terms of the way forward now, the fair process, because it's not only the attachment of that affidavit, it's also what I'd written on this matter. Yeah. Factually. Now, I think that irrespective of what that affidavit says, But I've got an affidavit, and we've agreed on a process here that if there are issues that I shouldn't deal with them elsewhere,
Yeah.
I can then refer to them, deal with them now. Because I think, Chair, you see, the problem that I have, and I know that this commission cannot create a platform from which judges are attacked and everything. I understand the sensitivity.
Yes, yeah.
But Chair, I think that we also want robustness. I will not go and attack judges. I believe myself to be someone who go at things directly. But I don't have an interest in attacking judges. But this judgment, Chair, I want to sit and before we even agree on the procedure, to even elevate some of the issues that are here, Chair, you'll actually be shocked. The last time you gave us a bit of guidance, Chair, and you know one thing I enjoyed being here the last few days, Chair, is that when I'm about to respond, you engage that judgment. And I think that probably 10 minutes ago, I would have said things that really, that's what you and Mr. Soni were trying to not to hear. But I'll tell you, this judgment is a rotten judgment. I want to say that. This judgment and the SCA judgment actually point.
But let me say, excuse me, why do you think it's not right that you reserve your comments on the judgment until we have seen what we want to see?
Okay, Chair, I think
is that, yeah,
no, Chair, I think I'll agree with that as long as we deal with it at the right time.
Yeah. No, you'll get a chance. Yeah.
And given what I've read, Ms. Montana must be given that.
Yeah, no, he must be given. I am myself interested in seeing at least your affidavit. I may be interested to see more of the other affidavits, but your affidavit, because you have said the facts that the court was given were not true or did not give a complete picture. And if it had looked at the affidavits that were excluded, it may have come to a different conclusion.
Chair, I accept your guidance on this matter. I think that it's not only what I said or the 7 other people said. I think that when you read the judgment, you look at what Matangoye and what Bergsman said in that issue. It should raise a big issue. But Chair, I'll deal with the issues at the right time, and I want to indicate to this court, Chair, all these issues that have been read as facts are in fact false. And that is why I was prepared without that affidavit. To just go into the thing to demonstrate to this commission. And that is why I was asking, how would the honorable judges, why would they do this to us? You know? Chair, can I make one point? Because I've been concerned with it for a while. The judgments on Plaza, all of them, Chair, from judgment on Timkulu to judgment on Sufam, on Siangena, you'll actually see, Chair, maybe there's a difference of a comma and everything. They are one judgment. And Chair, I'll elaborate at the right time once you have seen all of that, because I think that's where the problem is. And I'll pick up on this issue, Chair. I'll respect the judges, I promise you, Chair.
Yes.
But at the same time, we've got to tell the truth and be honest to ourselves, Chair.
No, that's fine. So, Mr. Soni, you will take charge of the process of obtaining the affidavits. Okay, all right. At least Mr. Montana's one.
Yes.
It may be that, I don't know, I just do have a recollection that the court papers in some of these press matters go into thousands.
They do.
So at least maybe the start is to get Mr. Montana's one, and then one can take it from there.
Yes.
Okay.
Thank you, Chair.
But Mr. Montana, you'll make your affidavit available to Ms. Ngata tomorrow.
I'll do that, thank you.
Okay, all right. And if there are matters, when we finish, Mr. Montana, if there are matters that either the commission has undertaken to look at, or you have asked that they be looked at, which by that time it might not have looked at or come back to you, just raise them when you finish all your evidence, if there are things, because we just want to make sure that every issue that needs to be looked at is looked at. Yeah. Okay, Mr. Soni.
Chairperson, then that is the last bit of Mr. Ngoi's contribution. I now want to deal with Mr. Oliman's report,
Yes.
which appears at bundle H. Chairperson, the information on which I want to put, the information that I want to put to Mr. Montana consists mainly of documents. So I'll just give a short introductory excursus on what I want to do this afternoon in relation to this.
Yes.
And Mr. Montana will know what type of questions I'm going to ask. Chairperson, Mr. Oliman gave evidence on, or came and testified on his report. And you'll recall that he dealt with 4 properties. The first one is the property that Mr. Montana owned in Parkwood, which he then sold to Precise Trade, represented by Mr. Van der Walt. Then it was a property in Waterval in Pretoria.
Waterkloof.
Sorry,
Waterkloof.
Yeah,
sorry,
Waterkloof,
sorry,
yeah.
Waterkloof,
Yes.
sorry, in Pretoria. And there was a property in Sandringham in Johannesburg, and then a 4th property in Hurlingham, also in Johannesburg. Now, most of the information is based, or most of the report is based on documents that Mr. Oliman attaches to his report. I'll just point out 2 other things, Chairperson. One is, based on the documents, it is quite clear that Mr. Montana did sell to Mr. Oliman, to Mr. to Precise Trade, his property in Parkwood. And it's also clear, Chairperson, that he purchased the property in his own name in Hurlingham. The other 2 properties Mr. Montana made some inquiries about, but those properties, although connected to Mr. Montana indirectly, in the sense that he made approaches about them, either in relation to his children's trust or himself. Those properties we know were transferred from the owners to Precise Trade. Now, based on that, what I want to do today is just to establish the relevant facts as they emerge from the documents. And Mr. Montana can having look at, having regard to what I ask, can either say, yes, I accept, that's what's contained in there. What obviously is going to be important, and that's where I would like to spend most of the time, is what inferences to be drawn from the four property transactions that we will be dealing with.
Okay, no, that's fine. I think because we're starting a new topic, it might be convenient that we take a short break.
As you please.
Let's just take a short break. I want to say 5 minutes. I know 5 minutes might be good for me, but I don't know whether, Mr. Montana, you said you were looking for your jersey and so on.
No, Chair. I'm 5 minutes.
You are
Chair.
fine. 5 minutes is fine.
As you please.
Okay, all right. Let's adjourn for 5 minutes. Okay, let's continue. Your mic.
Sorry, Chair. Mr. Montana, the first issue I would like to look at is the sale of the Parkwood property, and you'll find that the relevant facts are set out at Bundle H, SS 18, pages 34 to 39.
Chair, can I suggest,
Yeah.
or rather request to address you firstly on this issue before we go to the specific matters?
You mean in general?
No, no, no.
Or this
Specifically,
particular
this
property?
report. This report.
This report?
This
oh,
report, Chair.
Okay, all right, do that.
Because I think that there are two things, Chair.
Yeah.
Should this report be before this commission? I think let's start there. And Chair, I think you'll see my affidavit. I deal with all the properties. I'm not even getting into that. But the commission, Chair, should know what, in fact, it is trying to do. This report, it takes the views, it takes the positions of other people who make allegations. It's compiled by an investigator at the commission. It's put as a report of the commission. Now, these are untested allegations. I'm not engaged.
Let me say this because this might, certain things might be causing confusion. Before you proceed, okay, so I see that, so it's a report or investigator's report as opposed to being a report of the commission. So I'm just mentioning that so that that distinction is made. In other words, a member of the investigation team assigned to look into certain matters is supposed to have conducted investigation and looked at documents, and he then comes to certain views which I might accept or reject. So I just want to mention that. Then you can continue.
No, thanks, Chair. I accept that, Chair. Chair, let me start by quoting a judgment. I think it was Judge J. Davis.
You see, Mr. Montana, by coming to the commission, you might end up being a de facto lawyer.
Indeed, Chair. I think I'm heading that direction, Chair. And I think Mr. Soni can take me under his wing, Chair, until I also get to the level, Chair. Thank you very much, Chair.
Yeah.
Chair, Judge Davis, in a matter involving the SABC, he raised two important issues. And I just want to quote them quickly, Chair. He says, firstly, this is a matter that was between the SABC, former provincial SABC news editor, Mr. Charles Matrou. He took the Joe Trolle report on the SABC, editorial independence or interference at the SABC, on review. And this
What report, I'm sorry?
This was the Joe Trolle. You remember Joe Trolle?
Oh, yes, yeah.
Was appointed to investigate, his commission to investigate editorial independence at the SABC. He makes two important points here, and I just want to quickly quote them. The first one, he says, it offends one's sense of fairness. Even an investigator, and I'm saying in this case, this commission, were to only listen to the version of a complainant without considering the version of the accused before making a finding or recommendation. He also come and say, Chair, in the same judgment, he says, and this is very important, and this is my basis for looking at this report. He says it is equally worrying when an accused person hears for the first time, recommendations which adversely affect him when they are already made. Chair, I accept the distinction that you've made. But this report, Chair, somebody in the commission is given is going to investigate a particular area. He go and investigate it. What he does, if he does an investigation and says, I've spoken to everyone, I've looked at all the statements, I've spoken to all the relevant people, and these are my preliminary views, I want to put them before the commission. So it didn't happen. What has happened here is that the commission's investigate on PRASA went to take allegations that were made by Mr. Paul O'Sullivan in a 22-page affidavit that he put at Brooklyn Police Station and the Werksman's report. And these are now compiled into a preliminary report to the commission. Chair, I'll answer questions, any questions, because I agreed to come and testify before you, Chair. But this report, Chair, can never be actually what it says. Because this is an investigator of the commission. You know, I listened, Chair, when this thing was happening. Mr. Soni asked, and you asked for clarification, and they were clarifying and say, Mr. Montana bought properties for 36 million. Okay? Not true, Chair. But this report says that. Because it takes the views. You see, these people, Chair, who manufacture these stories about us, they don't themselves come to the commission. They put them as if the report is either a media thing or something. And then the commission takes them, or its investigators, takes them, and then they're channeled through the process. Because O'Sullivan doesn't come here and file an affidavit on his 22 and say, I believe that there's corruption, and I write it here. Then it's channeled. Because, Chair, he says, I've used bank statements, I've used other things, I've also used documents that are before court. So on the very matter we just completed, it is not only the High Court that ignored what I said even on these things and my version on this issue. The commission, Chair, ignored, they attach, they talk about everything. And I still make that distinction, Chair, that you've made. I just take it and use they take these things, they elevate it. It's presented before the commission. Chair, there's no reason. If I look at the litany, I wrote to the commission, Chair. You recall I even went to I wrote to the Judicial Service Commission. And the commission is actually breaking the very terms of that. This is one of the issues, Chair, that I raised. Now, here's the commission where there's a dispute on even facts. It puts this report, it takes the reports from other people who are protagonists in this battle. They don't file them, then they elevate. The commission then enters the arena in favor of particular people, and then I come to the commission. So the question that I'm going to answer now, I should be answering those commissions I should have answered during the investigation. Now I'm having a preliminary report on this issue, okay? Where myself, and I've chatted with other people, did they speak to you? The answer is no. Mr. Oleman is not here. So if you ask him, he was able to say Mr. Montana bought properties for 36 million, okay? Which is false. But they were presenting it as fact. I also mentioned something else, Chair, that the commission went and presented to the Chair that there's only one report of the public protector. And all other things, even about how we deal with court judgment. This report, Chair, the commission should say we've got information, we want to ask you certain questions, and then we're also going to deal with it into that. This report, Chair, I think if we were procedural, we deal with issues of fairness. We we deal with the issue that Judge Davis is saying that it is extremely worrying. This report should not be accepted by this commission, not because it contains the lies that it contains, but precisely because the process before it was tabled here, Chair. I should have been spoken to, 4 or 5 other people should have been spoken to. The documents that Mr. Oleman says he placed reliance on, he actually ignored them, Chair. Mr. Oleman ignored documents on a whole range of fronts on the PRASA issue, which has put me into dispute with the commission, Chair. Chair, if there was time, I would actually put an application, maybe it has not been done, applying to you, Chair, to say, I'm asking for this chap to be fired because he has actually misled the commission, undermined its mandate to reach to the truth. What he's doing, sir, he's fighting a battle on behalf of particularly vested interest in these matters. Chair, you remember I mentioned the issue about the NPA and the Hawks. Again, the PRASA investigating team ignored the facts and presented the commission with the facts that PRASA was fighting the Hawks to investigate these matters. When we know that the facts, in fact, are opposite, and in my affidavit, I've attached a lot of things. So I wrote to the Secretary of the Commission, why would this commission, or rather, why would the investigators in this commission pursue certain things, align themselves with certain people, and the facts that I put in, including in public statements, including some of them under oath, like the affidavits, they ignored them and they want to pursue. So this, Chair, what we have before you is this report. Is basically Mr. Paul O'Sullivan taking his affidavit, which the police in Brooklyn may not affected upon, which Werksman says there's actually no supporting evidence for this. Werksman said about it. But somehow they are getting to be investigators at the commission to say, accept this and do not accept this. So, Chair, I'm prepared to answer everything, but I'm saying this report, it's not worth the paper it's written on. It should not be accepted by this commission. And I think that, in fact, if we're going to deal with my properties, Chair, the commission must have its investigators to come and speak to me, prepare a proper preliminary report, and then the facts are tested here. What we have is these things are elevated as if the commission has done work, which it hasn't done, and I'm supposed to come here and respond to matters that the commission should have sat with me on the side, and then start to question me and verify the facts. So this is you're actually saying, Chair, if you accept this report, and I'm not saying the Chair has accepted, but the fact that is before us, you are basically saying the commission is coming to the ring. The people who are making accusations with me, they don't want to box with me. They are now putting Judge Zondo and the commission to box with me. So if I hit them, I still have people standing behind the judge. And I think it's not only unfair, but it actually fundamentally undermines the terms of reference of this commission, especially search for the truth, Chair. And I think that this is what has happened. And I take strong exception, Chair. Mr. Soni can continue asking me, but I'm urging you, Chair, that a report of this nature, which is showing, is so partisan, this report. And you see, if Mr. Oleman was writing this report and having his own dreams, is fine, Chair. He went to take people that I'm challenging. Some of them have said they want to cross-examine me. He has elevated their version. And it's elevated there. But fortunately, I'm here. And fortunately, I'm glad that you'll give me the chance. I'll deal with these issues in that way. But this report, Chair, shouldn't have been, when the country was being told, Montana bought 36 million. The properties worth 36 million. And my family asked, hey, you are so loaded, Montana. Where do you get this money from? So these are the things that we do, sir. So, Chair, I think that I want to put it. Yes. I'll answer specific questions that Mr. Soni wants to ask.
No,
that's fine. I do not accept this report, Chair, and I'll never accept it even tomorrow.
No. Mr. Soni will be able to say something in response if he wishes to. But what I want to say, Mr. Montana, is You have said that this report is based on Mr. Sullivan's affidavit. So I'm keen to see that affidavit. And then I think you said something else, also based on something else.
So in fact, it's based on three things which are attached, are part of my attachment
Yeah,
that I'll discuss with the team. The first
okay,
one is the
okay.
22-page affidavit by
Yeah.
O'Sullivan, Paul O'Sullivan. The second one is the report of Werksmans on the
Yeah.
same matter. And the third one, Chair, there's a chap who worked for PRASA, who worked with Mr. Molefe, who compiled. And knowing the chap, Chair, I can see that he wouldn't write an affidavit of that nature. So it's all of them. I've attached them so that the commission can see all of those documents, and I've attached them, Chair. I want us to have a look at them.
No, that's fine. But also another point I wanted to make is one which I think I've made before, namely, it's good that you came to participate, because then you can raise these things and say, here is something that is flawed as far as I'm concerned. Here is my side of the story. And with other people too, that the commission has been trying to say, come, let's hear. It's to afford them exactly this opportunity to say, so-and-so is saying these things to me because of A, B, C, D, or is basing this on E, F, and G, so that we have the full perspective, so that in the end, obviously, one will look at really what the evidence reflects. But it's good that you are here. You can raise those matters. Mr. Soni?
As you please, Chairman. Mr. Montana, I don't want to enter into a dispute with you about this. I'd rather ask the question. Just make 2 points. That you do not see a single reference in this report to Mr. O'Sullivan's affidavit. Secondly, you will see a reference in this report at many levels to Mr. van der Walt and payments that he made in respect of these properties, together with a bank account that his partner supplied to the commission. So for you to say that this is Mr. O'Sullivan, I have read Mr. O'Sullivan's affidavit or report or whatever it is to the police. I can say to you that Mr. Lopes's affidavit came last year, and it was the first time that anybody in the country knew how payments for the properties were made. And that came about because Mr. van der Walt had provided 2 letters to Mr. Lope, which are part of Mr. Lope's. I just make that point.
No, Chair. Chair, no. I think I'll accept your guidance that you've given, Chair.
Yes.
That the commission will have a look at that. I'm glad that Mr. Soni had seen the letter.
Yeah.
But you'll see, the letters and what they mentioned, Chair.
Yeah.
Chair, you'll see when you see the affidavits, the consent affidavits, that this has got nothing to do. I've read Mr. Lopes's affidavit, and I've read also the affidavit of Mr. Andre Wagner, which the commission, by the way, Chair, let me mention before we proceed. You see, Chair, the commission engages with someone. Mr. Oleman, he goes and interviews somebody. And this is Mr. Andre Wagner, the man who's involved in a partnership with me through a company called Midtown Brace. He files an affidavit. He says, this is my money. I have a partnership for development of properties with Mr. Montana. Okay? And he explains, he was interviewed, I think he spoke to the commission. He explained, and he filed an affidavit, Chair. He signed it. This affidavit doesn't support even this preliminary report in respect of this one of the properties we are talking about. What happened? We saw Sally DePierre, Ms. DePierre was here. We saw Louis Green, who in fact was, in my view, was subjected to a grilling, who was here because he contradicted what was said. And Chair, Mr. Wagner was not even brought here because he says, I don't do tenders with government. I'm not involved with PRASA. I've got a property deal with Mr. Montana, and it's a good property deal. Okay? And what do they say? No, we don't need you because you are not articulating this version that we want. So, Mr. Soni, with due respect, I hear what you're saying, but this report, Chair, once you have seen for yourself the affidavit of Mr. Paulo Sullivan, and yeah, the third affidavit comes from Mr., I think it's called Mr. Philemon Mamavulo, Paka Mamavulo. Chair, the enormous lies, but fortunately I'm here. I'm going to confront the lies, Chair, and deal with them one by one. We are here, but the commission belongs to all of us. It can't be abused by people. If Mr. O'Sullivan shouldn't only go to Brooklyn, he must file an affidavit here and defend it and make those accusations and be open to cross-examination. Now it is hidden under a commission's investigator. Now what do we do? Do I cross-examine this chap? And statements that are made to the nation are a preliminary report, Chair. Few days it was a full report, then we got the thing that is now a preliminary report. The damage that is done, now I must come afterwards to respond to lies, but it's been dealt with at the commission in this particular way, Chair. Now I'm going to leave it at that, Chair, because you've guided us.
That's fine. Yes,
let's go into the issue, but
yes.
the principle of it, I don't want us to put cracks over put plaster over cracks. This thing was wrong in a very fundamental way. If I say it was unfair, it's an understatement, Chair. The conduct of this chap, this investigator by the commission, was unlawful, Chair. And if the Chair had known probably a few months ago, I would have written and asked for this chap to be fired, because now I've been made to believe it is the position of the commission. But now it's quite clear that here's someone who's going. I asked the question, how was this chap appointed? I had to ask that question, Chair. Because I've never seen an investigator at this commission who aligns himself with the version he wants it to put on the table, Chair. Chair, the reason why I didn't come for 2 years here is because I've been fighting to say, no, it can't be done. I said, if you either we deal with the truth, or I won't come and testify. But Chair, I'm glad I'm here. Let's proceed with it. And I think Mr. Soni should not defend it, but should note my view until we have now compared that with the affidavits that are there.
Yeah, no, that's fine. I wanted to say something about Mr. Wagner, I think. I don't remember the name, but I do recall that on one of the occasions when you were appearing here, you did refer to a witness, and I think it was in the context of the issues of the properties, that you said, as I understood you, had deposed to an affidavit or had said something that you said did not accord or support a certain narrative. Yes. And I think you said he was not called to give evidence. Subsequent to hearing you saying that, I did ask, I think, I hope I'm not mistaken, I did raise it with the legal team to say, follow up on this, what is Mr. Montana talking about? Because it may be that sometimes somebody expects a certain witness to be called and the witness is not called for reason A. But when that person sees that this witness is not being called, he or she thinks it's reason B, you know. Sometimes there is a good reason, but when, you know, there is no communication or discussion, it's easy to think differently. So I'm just saying that when you previously mentioned something like that, raised it with the legal team to say they must look into that. Mr. Soni, did I raise it with you? Or?
Yes, no, you did,
Yes.
Chairperson. I'm going to
Yes.
address it.
Yes, yes. I do recall that you told me,
Yes.
I think, a certain answer. Yeah.
Yes. Mr. Montana, can I ask you to please look at, we're still dealing with Bundle H. Please look at page 198.
198.
Yes.
And there?
So paragraph 24, the report says, one of the directors of Midtown Brace, Mr. Andre Wagner, has undertaken to provide an affidavit setting out how it came about that the 11.5 million rand in respect of the Hurlingham property came about, which is referred to in paragraph 23. And at paragraph 24, the report continues, at the time this report was compiled, the affidavit had not been furnished to the Commission. So that's the answer, Mr. Montana.
Chair, I'm asking.
Well, you must read the last sentence as well. I think it's important.
Yes, once it is submitted, a decision will be made whether to supplement this report. Now, Chairperson, can I make Mr. Mr. Wagner's affidavit available to all of us
Okay.
to understand why no decision was made to supplement the report?
Okay.
Chairperson, this is the affidavit that Mr. Wagner eventually submitted to the Commission. Now, he deals with in paragraph 3 with the Hurlingham property. Well, firstly, he says he's a representative of Midtown Brace, which is a company registered in Botswana. And then in paragraph 3, dealing with the Hurlingham property, he says, Mr. Rian van der Walt and I have known each other since 1992. We are good friends. We have engaged in joint venture agreements during this time, Re-Elements Golf Estate and property in Kuurboom Strand. Rian van der Walt introduced me to ML Montana, which presented a property development proposal. I have never met Mr. Montana prior to this introduction. The parties, Midtown Brace and Mr. Montana, agreed to the terms and conditions of such a development and entered into an agreement during 2015. The development encountered several obstacles, resulted in delays and redirection of the original development and agreement. The company is satisfied with the current agreements in place to secure its investment. To cover the company against any losses, we have issued summons against Mr. Montana and awaiting default judgment if he defaults again. I further confirm that the full investment amount was paid over to Mr. Montana, totaling 11,500 rand. 11,500,000 rand. Then he deals with Midtown Brace and what its dealings are. He says Midtown Brace was a shareholder in Wetlands Country Retreat. Midtown Brace sold its shares in Wetlands to TMM during 2014 as per a sale of share agreement and in terms of the shareholders agreement. This was my only dealings with Mr. Mario Ferreira. The sale of share agreement, preparation and receipt of payments was handled by Mr. Rian van der Walt through an Investec account. You will see, Chairperson, two things here. annex the agreements in question. He refers to two agreements, his agreement with Mr. Montana and his agreement with Mr. Ferreira. Those agreements are not there. But what also emerges is there was, in fact, now a legal dispute between him or his firm and Mr. Montana. Now, nothing in the report, because when I go through the Hurlingham property, Chairperson, you will see that that's exactly what he said, that Midtown Brace paid the 11.5 million rand in respect of the property. This is what Mr. van der Walt said in his letter. So based on that, and I was one of the decision makers, thought that it was not necessary because it doesn't take the matter any further in relation to the report itself and throwing any further light on the purchase of the Hurlingham property.
Okay, all right.
Okay.
The agreements. Well, the agreements he refers to in 3.1 or 3.2 must be agreements
With Mr. van der Walt.
with Mr. van der Walt.
Yes. It's 3.5 that is the agreement with Mr. Montana.
Okay, okay, all right. Yes, okay. Mr. Montana, I think what Mr. Soni was doing is just to explain why Mr. Wagner was not called, but the affidavit is here. Do you want to say something on that?
Yes, Chair, I want to say two quick things.
Yeah.
In fact, this affidavit, you remember why are we here? Why are we discussing this issue, Chair? This commission, the commission investigated properties. It didn't investigate all my properties. It investigated certain properties where allegations of wrongdoing were involved. Okay? Now, they mentioned 4. Now, I'm glad it seems you are making progress. This affidavit, okay, it says, no. I'm Midtown Brace. I'm not involved in that. I've entered into a property transaction with Mr. Montana. I gave him 11 million rand, 11.5 million rand. He had to put, and I've attached, by the way, for your information, the agreement I've attached as part of my affidavit. Now, we are looking at properties that Mr. Montana bought properties for 36 million rand, according to this report. Okay? Now, this affidavit by Mr. Wagner disproved that, Chair. It confirms the fact that me and him had the property development. And he says, I knew Rian van der Walt, and I knew Mario Ferreira there, but I've got a transaction with Mr. Montana. And I'm not involved in price, I'm not involved in anything. Now, when Chair, you are asking, Mr. Soni confirmed, Montana bought properties from stolen money, effectively, that was being said. Here's an affidavit, Chair. I'm not dealing with one, we'll deal with we are coming to the others. We are dealing with one. Here's an affidavit, it tells us that someone who's involved in farming, in mining, gets involved in a property deal with me. We buy a property, Chair, and I'll explain the details of that transaction. Okay? Now, by association, when they find that, hey, this guy knows somebody else, they say, no, the money for buying this thing should come from that side. Is the relationship that is set up to pay Montana corruptly. And Chair, the reason why, because you want to hear both sides. You want to hear when I'm accused that I bought properties. But here's a man who's saying to the commission, I'm deposing to an affidavit. And I'm saying that the allegation that I bought a property with Montana as part of a corrupt deal is false. I'm not even involved in those kind of transactions. Chair, there is no, for a commission interested in the truth, there's no way that it will invite Ms. De Beer and ignore, because the biggest, probably one of the biggest monies in that 36 million comes from Mr. Wagner. And I wanted the commission to pursue it and say, we want to prove. Who draws Mr. Wagner, Chair? It's Mr. O'Sullivan. Okay? Now today we are told that this thing doesn't add value. Chair, this thing adds value. You know what the value it adds, Chair? It says the narrative about all these 4 properties is actually false. There it is, Chair. And so, Chair, I want us to go into detail. I'm raising it as a principle that when the commission says there's no need to pursue it, okay? No, I want to prove, Chair, that the story about 36 million rand worth of houses bought by Montana is so false. It's in the preliminary report, and that is why I've even looked at the accounts, Chair. One of the things that O'Sullivan did was to provide the accounts, and you see that this 36 million, how that it doesn't come from anywhere else. It doesn't come from an independent investigation by this commission. If someone was trying to extort money from me, I refused. Again, it's in my affidavit. And then they decided to go to me and they created a story. And I'm simply saying, Chair, that this affidavit, if somebody makes an accusation that Montana stole money and bought properties, there must also be this affidavit that says, no, Montana didn't steal money. He entered into a property development with me. His contribution to that. I mean, when you look at this report, Chair, let me read the last thing. The last sentence there. Not the last sentence. The one before where they are mentioning that, oh no, there it is, Chair. It says, this man paid 11.5 million. And Mr. Montana didn't even pay a cent. That money, the 2 million, was paid by Mr. Rian van der Walt. Chair, is false. So here we stand in front of the nation. And some of us who wake up in the early hours of the morning to go and work for this country, we are then being tarnished that we are thieves. I enter into a property deal. I sell one property. I put the money into another property. Okay, this guy, if he had come and interviewed me, Chair, or probably the other people, he would have realized that Montana sold property X. He didn't take that money. He paid the bank, and I instructed Van der Walt, the balance of that money, it must go as a deposit into that property or pay for that property. That's what I'll demonstrate here today, Chair. So this story about Montana being rich, stealing from brass and buying 36 million rand worth of properties, and I think we must deal with it. And I think, Mr. Soni, you said you're going to deal with, you want to deal with the facts. I want to assist you with the facts.
Yeah.
But these things that we have before us, it's not a fact, it's fiction, Chair.
Now, Mr. Soni or Mr. Montana, in your affidavit that is being prepared in terms of the annexures, is there a distinct section where you deal with the issue of properties?
No, Chair, in great detail.
In great detail.
I know this is one of the accusations that have been made against me in public.
Yes.
I wouldn't come to this commission and not talk about my properties.
Yes.
Chair, I deal with each and every property, how each one of them was funded, precisely because I wanted to put this lie to rest for the last time. You don't deal with it, Chair.
You know what I'm thinking, Mr. Soni? It may be convenient that Mr. Montana gets questioned on the properties when one has seen what he has to say about each of the allegations connected with all of these properties. Because without that, we might spend a lot of time because one is not looking at what he has already written. And we could take maybe half the time if we were to do it that
I
way.
agree entirely.
Yes.
Chair, I've got everything I've written on this thing. If the
Yes.
commission asks me to read them into record,
Yeah.
I can do that now, Chair.
No, I think I would prefer to read it before you give evidence because then,
Okay, Chair.
then I'll be in a position, and Mr. Soni would be in a position too. I would be in a position to say, in the light of your response, the only issues are really A, B, C, D. So let's focus on those issues. Then we don't have to spend too much time.
Chairperson, may I augment that? And that we must do because Mr.
Yes.
Montana must be entitled to.
Yes, yeah.
But one of the purposes of the 10.6 directive was to say, tell us what you admit and what you deny. So if I'm just giving, and that's in addition to what you said,
Yes,
Chairperson, it
yes.
will shorten things a lot
Yes.
more. If I could just take, and I'm doing it for Mr. Montana's sake, at page 34, if we're, that's of SS 18, bundle H.
Page
It
34.
says, page 34. Paragraph 2 says, Mr. Montana purchased the Parkwood property on the 4th of July for 1.85 million rand. Mr. Montana can say yes, no. So one then knows that when one is dealing with the, and those are just facts. I'm not
Yeah.
asking him to
Yeah.
deal with the inferences,
Yeah,
just the facts. Then we say that in paragraph 3, there is an email from Mr. Montana's private banker which says the property is valued at 3.5 million rand. It doesn't mean he accepts the valuation, but merely say, yes, I accept that that's what my private banker said. Then at paragraph 4, we say, Precise Trade and Mr. Montana entered into a purchase and sale contract whereby the property was sold. So that would just eliminate all the factual disputes, and we'll get into the real disputes as to where did the money come from, Mr. Montana's explanation, and so on. So it is not amending what you are saying, it's augmenting.
Yeah. So for example, I mean, you said already you've got this story, you've got what you have to say in your affidavit. So when one has regard to whatever the documents say here and to what you have to say, one ought to be able to say there is no dispute in terms of facts on the following issues. The disputes are only in regard to A, B, C, D.
Absolutely. And it'll save us plenty of time.
Yes. So, yeah, you want to say something?
Chair, I've accepted your guidance.
Yes, yeah.
But
yeah,
I also do not want, because we are going to now lose people. You see, Mr. Soni, Chair, we mustn't forget what we are dealing with here. The investigators know that the property in Parkwood was bought by me, was paid for by me. I don't want to go into detail about it. And they are talking about they're talking about the valuation when I bought the property. They're not talking about when I bought when I sold the property. Okay. Now, Chair, and I think that the issue why we are discussing the Parkwood property. Let's remember why we're discussing it. Is because they are saying I sold it for 6.8 million above the valuation. They're not telling you what valuation. The valuation, they are taking the valuation that I bought when I bought the property. Because the bank had to finance me. So it did the valuation of the property. And it says, no, we can finance you because the value of the property is far above the value of the bond you are requesting. So they give me a bond. But then a story is created that no, Montana, he sold it for 6.8. This property is worth 3.3 or 4 million. Okay? They're not telling you, Chair, that the property was, I'm not being asked. How did you develop this property? How much did you spend on it and everything? Chair, I've got pictures. Fortunately, I've got pictures of this property. Then and now. I bought a wreck, Chair. The bank financed that. Because of its location, it's far about that. I modernized the property. What these people want, Chair, they don't have an evaluation. They said they had a neighbor saying this property should be 4 point. A neighbor who's not even been inside my house. He knows the value of this property. And then, Chair, they're saying he sold it for 6.8. You know what the 6.8 is saying? So they're saying between the 3.3 that the bank evaluated when I bought the property and when I sold it, they then say it's a bribe from Rian van der Walt. Okay, Chair? So I don't want us to deal with this thing as if
No, that's important. In the end, you are right to say, to the extent that this is said on the basis of suspicion, that's a bribe. This is my answer. It is not, or it can't be, because of these facts. So we mustn't forget that. That's it. That's important.
No, Chair, I'll keep on reminding the Commission.
Yeah.
Respecting progress, and I think Mr. Soni and I agreed that we must move with speed.
Yeah.
But Chair, again, Mr. Soni, when he augment, he says regulation 10.6. Chair, I do not want to go back. I've said it on record.
Yeah.
And I've said to the Commission, I wrote to the Commission, you as a Commission issuing a 10.6 against me, you are going to the Chair to ask for a regulation 2.6. You know it's unlawful to ask the Chairman to do that because I've already agreed, I've already put a draft affidavit. And Chair, go back. My first draft I gave to this Commission in 2019, August 2019. I'm already writing about my properties. I never, Chair, I'm not hiding anything. The Commission was trying to manipulate things. And I said, no, I stood my ground, I refused. And that is why, Chair, when you look back, I spoke to some people within the Commission. I asked, how do you, after I've given a draft and made a commitment, to respond to all Rule 3.3 notices and all the allegations that have been made against me, why would you go and ask the Chair to issue a 10.6? And I said, we are going to fight because I'm not going to accept it. It's actually unlawful. What you guys are, because Chair, the Commission's legal and investigating teams, they were trying to impose and they were trying to get certain things that they want before this Commission in respect of me. And I'm one person, Chair, who has refused. I say, we are going to put the total picture. So I want to answer these questions, Chair. But I'm going to at various stages ask the Chair, with your permission, Chair, can I come in there? Because I'm giving this example, Chair. If you listen to people like Montana has been paid a bribe. I want to put before the Chair, this property when I bought it, the wreck it was, and the value by the bank, what work I did, and what was the end product, and then ask. But if I'm told, I don't even know which neighbor tells Paul O'Sullivan that I bought that this property should have been 4.8. A neighbor who can't even develop his own property. Yet he can provide an opinion on the value of my property. Then this Commission come and ask me and say, no, your property should have been 3.3. It's shocking. But I'll leave it at that, answer the question. And then, Chair, as long as you admit me where I feel very strongly on this thing, where I need to correct the facts, you allow me to come in that respect.
How far are you and the legal team to finalizing the annexures for the affidavit?
No, tomorrow, Chair. I think we've even identified areas that the Commission should focus on. So, Chair, I think we are one. I think the fight is gone. We are no longer fighting. I'm here, I'll testify, Chair. So tomorrow I'll give them all the evidence, and then we'll move forward on that basis, Chair.
The reason I ask Mr. Soni, you remember that, and Mr. Montana will remember that I did say previously what we will do with the affidavit once it is ready is something we'll decide there. I'll decide then. because of the time constraints. Now, if Mr. Montana's assessment that tomorrow should be, whatever is left to be finalized should be finalized, if that is correct, then it may be that all we need is that it gets finalized tomorrow, and then one can look at it with special reference to the section relating to the properties, and then take it from there. It may well be that when his response to the issues of properties is looked at, is considered, it may well be that it might be necessary to maybe do some further limited investigation of some issues, I don't know. Or it may be that it's not necessary. But certainly in relation to properties, it's going to be important that I hear what he has to say. And as I say, I want to hear when there is something in writing. And then what one does with the balance of the affidavit might also be something to look at. If the position is that the section on the properties has got to be dealt with because that's part of what he was asked to respond on. But maybe is not going to get a chance to give all the evidence about other matters that are in the affidavit. It may well be that we might consider whether there should be a separate affidavit that just extracts from his affidavit the section that deals with properties. You know. So it seems to me that, but let me find out, is it your understanding too that tomorrow the issue of annexures and whatever in regard to his affidavit might be sorted out?
Chairperson, let me say I've, for various reasons, have not involved myself in dealings with Mr. Montana outside the commission.
Yes.
But, Ms. Ratanga is...
Yes, do you want to find...
they have arranged that already.
Yes.
It's supposed to happen on Friday, it didn't. As I understand it, that is the arrangement for tomorrow.
But in terms of whether it can be finalized, the process can be finalized tomorrow, is she in agreement as well?
She thinks by Wednesday, Chairperson.
By Wednesday, okay. In any event, that's quite close, I think, yeah. So I think, therefore, what we should do is not move forward on the issue of properties for now. Let's get that part sorted out. And then once I have seen what he has got to say on the properties, then we can take it from there. Okay, is that fine, Mr.
No, I think it's fair. I'm happy with that.
Yeah. I think what the effect of that arrangement for present purposes is, therefore, I guess, that if there are other matters, but I think the Parliament document was the last one that you wanted, yeah. So from your point of view, you have nothing further for today. No. Okay. And I guess that to the extent that Mr. Montana has throughout indicated that he deals with certain things in his affidavit. We can't deal with those either because the affidavit must still be finalized in terms of annexures. So that being the case, I think it would mean we should adjourn on the understanding that soon another date will be given, maybe another evening, and then we'll take it from there. Is that all right?
Yes.
Okay, all right. We are at 17 minutes past 4. So I think let's adjourn then, and then we'll arrange a date. But the sooner the process of sorting out the annexures to his affidavit is finalized, the better. Yeah. Okay, all right. I think we agreed. Yeah. Okay, we are going to adjourn for the day. We don't have an evening session today. We're going to probably have it if we were continuing with Mr. Montana. Tomorrow, for the benefit of the public, I'll be hearing Mr. Gogo's evidence in regard to ESCOM. Yeah. Okay, all right. We adjourn.
As you please.